This is a webinar on employment-based immigration options. My name's Catherine Del Rosario. I'm an attorney with McEntee Law Group. We are based in Chicago and we practice exclusively U.S. immigration law.
Hi, everyone. My name is Anna Potter. I am also an attorney at McEntee Law Group. I am not based in Chicago. I am with you guys from San Diego, California today, and looking forward to sharing a bit about employment-based immigration options, focusing on the green card avenues. Our colleague Ryan did a webinar a few weeks ago about work visa routes. So this is what green card options that are available to those on employment-based visas.
Okay, and then just as a reminder, this presentation is general information only. We are covering a lot of ground in a short amount of time. So all the timelines that we provide are estimates as of today, and they're subject to change based on the government's workload. And your specific facts of your situation are going to be key to how you should proceed. So please contact an attorney, whether it's us or another immigration firm, to really like fully explore what your options would be. I'm going to give a brief roadmap of what we'll chat about today. We're going to go through the EB1A and EB1C options, the EB2 NIW, which is the national interest waiver, the EB2 and EB3, which are closely associated with the PERM green card process. And then we'll briefly touch on adjustment of status versus consular processing, which would both, the outcome of both would be a green card for you to be able to work and live in the United States. And then we'll leave time, of course, for questions.
Yeah, so as Catherine said, we're trying to cover a lot of ground in a short amount of time here. These are our employment-based green card options here. Today, we'll be focusing on the ones that we encounter the most, which are EB1A, EB1C, EB2 National Interest Waiver, or NIW, and then the PERM later certification routes for EB2 and EB3. Any one of these could probably have a solid, at least hour-long webinar in their own right. And we have done webinars actually on these individual ones, but so this is just meant to be very high-level overview to hopefully give you an idea of the different routes here. We'll start though with our first one on the list here, which is EB1A. And for this, you can think of it like the green card version of the O1A visa. So again, that was covered by Ryan in the work visa webinar, which if you haven't checked out, you should look at the recording of if you're interested in seeing more on the work visas. The O1 visa is for folks with extraordinary abilities, and this is the green card version of that. I sometimes like to refer to it as the older sister of the O1 because it's similar, but the standard is higher. So it's a little bit more elevated. You're showing that you are among the very small percentage at the very, very top of your field. Um, One nice perk about this is that you can self-petition for the O1. So while you can also have your employer sponsor this green card option, if for whatever reason they are not open to an EB1A, but you think that you may qualify, you can always look into getting a consultation and perhaps self-petitioning for the EB1 if you feel that, you are extraordinary. So the requirements for the EB1A, you need to show, again, extraordinary ability in your field. More on this in the next slide. This is generally shown by sustained national or international acclaim. So we'll get into more of the nitty-gritty in just a minute, but you need to show that it's not just a one-off, that you've had sustained acclaim in the area of your expertise. If you are young in your career, don't be discouraged because, the policy manual does state that, young people can still qualify for the EB1. They look at the holistic picture. So don't think that you need 10 years of a claim necessarily to qualify. You also need to show evidence that you will continue working in your field of expertise. So, if your employer is sponsoring you, then great, the employment contract can serve as proof of the continued job offer. If you're self-petitioning, then, we may need to get more creative. We may need to show intent to hire letters or something to show, to help demonstrate that you will continue to work in your area of expertise. And you also need to show that your entry will substantially benefit the United States in the future. Okay, so showing extraordinary ability. If you have seen, webinars on the O1 in the past, this might look familiar because kind of similarly, you need to show either a one-time big prize like an Olympic medal or an Oscar, but if you don't have one of those, then you need to show that you hit minimally 3 of these 10 listed criteria here. Ones that we usually rely on for our cases that we see often are leading or critical role at a distinguished organization. If there's a high salary, we love showing that too, because it's hard for the government to argue with numbers. We love showing really objective evidence like high salary, if there's any press out there about you, if you've won awards in your area of expertise. If you are a startup founder and maybe you're not necessarily pocketing a high salary yet because everything's going into the startup, we can also refer to your shares in the company. And if there's a valuation, we can show, that that's been used as evidence in that regard as well. So here's the full and complete list. You need to show that you hit minimally 3 of them. And we like to take the approach of not necessarily trying to hit as many as we can. We like to pick, if there's only 3, then great. We'll just focus on the 3 strongest ones, or the 4 strongest ones. It's sort of that's our approach here at McEntee Law Group, is just not feeling like you need to fill every bucket, because sometimes the weaker ones make the overall case look weaker. And so, we're happy to help look over your evidence, see which ones would be best to hone in on. One final thing that I will note about the EB1A is that it is quite RFE prone. Immigration practitioners across the United States have all been observing an uptick in RFEs. That's a request for additional evidence. So even the strongest cases seem to be getting these. I would say just expect an RFE on EB1As. You are able to overcome them. We've had tremendous success getting all our EB1As approved, but we have been noticing an uptick in RFEs on this category. Next, we've got EB1Cs. So you can think of this one like the green card version of the L1A visa. The L1A is a visa for multinational managers, and this is the green card version of that. So you can either be a functional manager, which is managing an essential function or department or division of an organization, or you can be a people manager where you are overseeing direct reports. They do need to be degree holding professionals. Typically, we see people managers are just a little bit easier to get approved, again, because think of how clearly objective that evidence is. You're showing, here's the org chart. I am clearly the manager. These 3 people report to me. Here are reviews I've done for them, approving time off, etc. Functional managers, you need to overcome a little bit more of a hurdle. You need to show what is the function managed? How is it so essential to the company? How do you oversee the day-to-day, objectives of that function? Not to say it's impossible, but just in terms of functional versus people manager, that's the distinction there. Requirements. So there's a lot needed from both the employee and from the company on these types of cases. You need to show an employment abroad. The employment abroad has to also be at an entity that is related to the U.S. employer. So that can be, for example, a subsidiary or an affiliate. There needs to be a corporate relationship between the U.S. petitioner for the EB1C and the entity abroad that you have 1 year of experience at. The 1 year of experience needs to have been within the 3 years prior to you entering the United States, and it needs to have been in a managerial or an executive role. We also need to show that the US employer has been in business for at least 1 year and has the ability to pay your salary. So that's where, again, the documentation comes in to help establish the corporate relationship between the entities. It also comes in to show that the US company has been doing business. So maybe we'll provide bank statements, salary statements showing that they're paying their employees, a lease showing that they have a work site that the employees are working at, that type of evidence from the company. Then we need to also show, again, proof of your management. So whether that be organizational charts, big policies that you've put forward and drafted, et cetera. And the position that you're being offered in the United States also needs to be managerial or executive as well. Moving on to our EB2s. This is the national interest waiver, and you can also self-petition for this one as well. So just something to think about that it is an employment-based green card, but you are able to self-petition for the EB2, just as you are able to for the EB1A. For this category, we are trying to convince the government that your future work is in the national interest and they should waive the perm labor certification. If you don't know what the perm is, Catherine's going to go into that in just a moment. But basically, we're trying to convince the government that you don't need to go through that route because your future work is so, important to the national interest in the United States. So to show this, the main requirements are an advanced degree, either a master's or a PhD. I will say PhD is looked upon much more favorably, especially in this administration. But if you don't have either of those, you can also qualify by showing a bachelor's degree and 5 years of progressive experience. Want to show progression and advancement in your career, but that's possible too. Um, if you don't have an advanced degree, I'll have more on this in the next slide, you can argue exceptional ability. It is like a mini EB1A. It's easier to prove and there's more specific and tangible items, but that's an option as well. Once you have shown either advanced degree or exceptional ability, then there's a three-part, three-prong test that we'll need to hit. The first is showing that your proposed work has substantial merit and national importance. So let's break down this sentence because there's a lot there. Proposed work or proposed endeavor, that is the specific task or project or activity that you will be undertaking. So this is the what component. Maybe it's showing that there's a national problem or an industry that needs something. For example, robotics helping surgeons, in the surgery room. That would be the what. Then you need to show substantial merit. Generally, any activity that benefits science, culture, technology, and arts can be shown to have substantial merit. It's also helpful to show economic benefit here, but it's not necessary. And the last element of that sentence was national importance. So this can be the part that USCIS hones in on a little bit more nitpicks in some of their requests for additional evidence, but we need to show that the proposed endeavor has national importance. It goes back to that first part of the definition. If you have explained the proposed endeavor well, then typically you'll have an easier time showing that it has national importance. Then we move on to the second prong, which is showing that you are well positioned to advance your proposed work. We usually argue this like a mini EB1A, and we show evidence about past accomplishments. But the difference is that the EB1A is past looking. So remember, we talked about sustained acclaim, and we're looking at all of your achievements in the past. The national interest waiver, the NIW, is future looking. So you don't necessarily need to show that you have a ton of past accomplishments, but past accomplishments are very helpful to show that you are well positioned to advance the work in the future. So that's where any record of success, any patents or publications or investments can all help to show that you are well positioned to, further this endeavor. And then the last element is to explain the why America should waive the labor certification, that perm labor certification requirement. Generally, if you demonstrate the first two prongs, then this should be relatively easy again. So a lot of the NIW filing is kind of balancing on prior arguments. In this next slide, I'm just going back quickly to where I had mentioned that if you don't necessarily have an advanced degree like a master's or a PhD, you can show exceptional ability. And so these, we need to hit at least three of these. As you can see, they're not as robust as the EB1A requirements, so they're a little bit easier to hit. Showing your academic record, letters of progressive experience, a license to practice. These are things that they consider, and USCIS will also consider comparable evidence. If maybe your field, if maybe none of these apply directly to your field, then we could potentially argue that, there's other comparable evidence to consider as well. I'm going to give a similar disclaimer here that EB2 national interest waivers have been under heavy scrutiny lately. Again, practitioners all across the US have been noting this. And so just kind of preparing from the outset that a request for more evidence and RFE is very likely for these. Next, I'm going to pass it over to Catherine. She's going to speak a bit about that perm labor certification and what that route would look like.
Okay. Thanks, Anna. So the perm labor certification is also another pathway to a green card. And I would note that this is probably the most common pathway for most employees who are trying to live and work in the US permanently. Um, Most of the categories that we're going to be going over today are EB2 and EB3 that will require the filing of a perm. And almost all full-time, non-temporary positions could qualify. For example, we've done them for software developers, but also cooks. And in some cases, like caregivers or nannies that with like special circumstances. And a lot of the time, those who will start the perm process have gone through H-1B, although that's not required. But it's pretty common for that to be the trajectory. So if you're familiar with H-1B, you know that the focus of that visa is, looking at whether the job requires a bachelor's degree normally, and if you have that specific degree. With perm, the focus is a little bit different. The goal is to protect US workers. So through this process, we're trying to show that there aren't any able, willing, qualified, or available US workers to accept the job. And the hope is that the foreign national that's being sponsored is the right person for at this right time. Um, the perm is the first in a long three-step process towards a green card. And I would note that employer is exclusively responsible for all costs at this stage. I want to distinguish what the differences are between the EB2 and EB3. So EB2 is going to be for positions that require an advanced degree, such as a master's or a doctorate. And if there's no advanced degree requirement, then the role must require at least a bachelor's and 5 years of professional experience. For EB3, the standard is a little bit lower, and there's three sort of categories within EB3. There's skilled workers, where the job requires a minimum of 2 years of work experience, and the job is not temporary or seasonal. The professionals category for roles that require at least a bachelor's degree, and a bachelor's is normal for this type of job. And then other workers, so those performing unskilled labor requiring less than 2 years of experience, also not temporary or seasonal. And I guess it's important to note here that you might have a master's or you might have a bachelor's and 5 years of experience, but the focus is on what does your employer require for this role? Because that's what's going to determine whether you fall into EB2 or EB3.
It's actually employers can get in a lot of trouble for tailoring perms to your qualifications. So that's a really important reminder, Catherine, that exactly you may have a PhD, but if they typically just require a bachelor's level for the role that you are in, then we do have to go with that for the perm.
Okay. So I want to go through this is a simple way of looking at a really long process. But basically, at the beginning, the attorney, the employer, and the employee, we all put our heads together to establish role, a set of job duties, and the minimum requirements for this position. So when Anna mentioned that a role can't be too tailored, this is what we mean. The company has to say what at minimum do we require for this role, and nothing more than that can be included. Um, and then on the other side of that, employee has to show that they gained all of those skills, met all those requirements prior to working for the employer. There are exceptions to this. So if you um, have significant experience with the sponsoring company, we can look to that experience, but only if it's in a role that's 50% or more different than the one that you're being sponsored for. Keep in mind, perm is for a future job role. So you don't necessarily need to be in this role right now, but it's at the time that you receive your green card, whenever it is, the idea is that you step into that role.
And that's another good reminder too, because some companies are quick to promote. So if you know that this is going to take at least a year and a half, and your company is giving out promotions every 6 months, every 12 months, and you may be an engineer now, but you're very likely going to be a senior engineer or a managing engineer, that's important at this very early stage to let your attorney know, let your team know, so that maybe you're crafting it for the role that you're going to be in closer to the point that you're going to be, getting that green card.
And this might be especially, relevant if you are someone from India or China, where there are long wait times for a green card, because it may be safe to assume that you're not going to be in the role that you're in like 7 to 10 to 15 years from now. So it could be a wise idea to kind of look forward, forecast a bit what your role might look like then, because otherwise, um, we may need to restart. So the job that we come up with and the set of requirements that we establish from the very beginning, that is going to be the same set of things like throughout this whole process. It's set in stone. You cannot change it. If location changes, if salary dips down, these are all like significant factors that, you may need to restart the perm. So we spend quite a bit of time on this part. Once that role is established, we file what's called the prevailing wage. So this is us presenting the Department of Labor with the role that we've come up with. And then that officer will determine what's the prevailing wage or the going rate for this type of role, given all its requirements, whether, um, you're going to have direct reports, um, if you're going to require, many years of experience, what should this person be paid in the city that they're going to work in? It's distinct from like the H-1B context where when we present the role to the Department of Labor, we get to categorize it ourselves. We can self-select and we make our best guess based on experience. And then, but with prevailing wage, it is really up to that officer. We point them in the right direction, but they can really, choose how they will, like how they think it best fits into their directory of many occupations. I put a time estimate here. I can stand by this today. It's still at 6 to 7 months. So during that time, we would also be working to get letters of experience from your previous employers to document that you have the experience that you say you do, that qualifies you for the role. Okay, so let's say 6 months have passed, prevailing wage gets issued, and the wage looks good. Your employer is agreeing to pay you that wage when you get your green card. They don't have to pay you this now, but they will in the future. Then we move to what's called recruitment. So there's a test of the labor market. This is where that goal of trying to protect US workers really comes into play. The Department of Labor requires that certain ads are posted for the role to give people a chance to apply. Every resume or application that comes in must be properly disqualified, um, which sounds tough. This sounds like a tall order, but I will say that the recruitment process and the perm rules actually have not changed that much. So there are certain aspects of it that are a bit antiquated, and that's like to your benefit. So, for example, the Department of Labor asks that we post in the Sunday paper or the state workforce agency. And I don't know about you, but that's not where like I'm looking for a job. I'm gonna go on LinkedIn.
Radio or
Yeah. Um, so that's we have to do it. That and recruitment can take anywhere from 2 to 6 months. The variance in that time kind of depends on, how many applicants does the company get? How quickly are we able to sort through, screen, interview if we need to, and determine um, whether anyone is truly qualified. And this is where this recruitment process really differs from
real
the
world.
type that you're probably used to, where an HR recruiter could meet someone and say, I really think they're going to be a great fit. Like they're going to fit the company culture. We get along well. They seem great. Like none of those considerations can go into the screening process.
Or if someone is rude, things that you might disqualify someone for if they showed
Right.
up late or even missed the interview, you have to try to reach them again. There's no like personality. It's all just straight minimum requirements. So it is, as Catherine said, very different than real. It's a fictionalized kind of recruitment scenario.
Yeah.
And it is very important for if you are the employee for you to have no part in this part of the process because that could
Exactly.
really taint the perm journey.
Yeah. So you're not interviewing anyone. You're not going through
Not looking at
applications.
the
It's going to be
resumes. Yeah,
right.
nothing.
It's going to be your HR handling it, and they're going to go by the list of requirements that we set right at the beginning, and only those set of requirements. And then if all applicants can be properly disqualified, then employer files finally what's called the labor certification.
One question,
This,
Catherine. Sorry
yeah,
to interrupt. What if we find somebody qualified? Do we have to hire them? I sometimes get asked that where people panic.
that's a good question. No, they don't have to hire. Um, they do have to offer or stop this process. So if someone is like truly, truly qualified, then it can kind of halt things at this stage. But if that person declines, maybe they don't want to move, maybe the
The
salary is
salaries.
not
Yeah.
doesn't work for them, then company can say they did their due diligence and then proceed with your case. Okay, so the labor certification is basically an application filed with the Department of Labor telling them, hey, employer, we did everything we need to recruitment wise. No US workers were qualified, and we want you to believe us. And then it also establishes your priority date, which is your place in line for the green card. Now, perms or labor certifications, we use this term kind of interchangeably, are subject to audit, which is kind of like a request for evidence. And there are certain, so they can be random, which we've seen less and less audits in general since the Department of Labor switched to a new system last year, but that's not to say it doesn't happen still. And then other audits are triggered. But at the start, we will flag for you what factors would trigger an audit because we could very well overcome them. So some examples would be if there's a foreign language requirement for the role. That will trigger an audit, but there could be a very good reason why employer would need that. Maybe they do a lot of business with the Spanish speaking community, the Chinese speaking business community, whatever it is, that the person who's going to be in this role has to have that language ability. We just have to show the business necessity for that requirement. And you can guarantee there will be an audit, so it will kind of push back our timeline a bit. Another thing that triggers audits is, let's say you, the employee, are like related to someone in, an officer or an executive in the company. That will trigger an audit. The real concern there is, can the company guarantee that, you know, potential applicants aren't going to be discouraged from applying, that they're going to be given a fair shot. So in that case, we just have to show that you and the family member are also shielded from recruitment and not involved in any way. I'm trying to think if there are other audit triggers that come to mind for you, Anna.
I'm trying to think too. I think language is the big one. Um, Yeah, nothing else comes to mind at the moment. But I was going to ask Catherine about timeline. So labor certs we're seeing take about a year from when we submit them, but how does an audit add to that?
I would say it would add 6 months to this timeline. I mentioned just a bit ago that the Department of Labor moved to a new filing platform. The hope is that it's really nice. It's more streamlined, it's more efficient. The hope is that this should cut down on processing times, but that that platform was just launched last June, so I think it's like yet to be seen what the benefits for processing times will be.
Okay, so you saw Catherine mention the priority date. And that I like to refer to as think of it like when you go to the deli and you grab a ticket from the counter and you wait for that ticket number to be called for you to go up to the counter. You could think of the priority date like that. Um, that's your ticket for when it gets called. That's when you can go forward and move on with the next stages of the green card application, which is the adjustment of status or consular processing. Um, this is a snapshot. It's
Sorry, Anna, I guess I should mention, sorry, I guess I should like close out that
yeah.
last piece of the labor cert. So before we head into this, sorry about that. So once the labor cert is approved, that is the Department of Labor saying they agree. There's no US worker that's qualified for this role. And now we can move our focus, pivot to an actual change in immigration status. Because so far, all we've been dealing with, the only agency we've been dealing with is the Department of Labor. So
Yeah.
that's kind of like how we get to this point.
Yeah, that's a great point. So once the Department of Labor signs off on the perm, and actually before even we get to the adjustment of status, you'll also have to file what's called an I-140 with USCIS. I call that stage the show me your document stage because the perm is company owned, right? It's the company saying, hey, we have this software engineer position. Here's all the recruitment we ran. We found two people that applied. We disqualified them because they didn't have a relevant degree or the relevant experience. Mr. Jones is who we're going to, file this labor cert on behalf of. The Department of Labor says, okay, all good. Then the next stage is Mr. Jones giving his background. Here's my degree. Here's my letters of experience showing that I do qualify for this role. Then once that's approved, that's when we really start paying attention to this visa bulletin to know when can we apply for that adjustment of status from H-1B to green card, or if you're out of the US, do the consular processing for the green card. The visa bulletin is released every month. So this is the latest one from November 2024. We can see the different categories listed here. So first would refer to EB1. So if you are EB1A or EB1C, like the ones we talked about earlier, you'll see that that's actually current for most folks, except for nationals from China, India, Mexico. Actually, Mexico and the Philippines are current too. So China and India have retrogressions here. You can look at EB2 in the second line there for national interest waivers or the perm-based EB2, and then the third group for EB3. That's when you'll be able to come forward to file for the adjustment of status.
Okay, and I would note here that EB2 has generally moved faster than EB3. So historically, immigrants are more keen on getting into the EB2 category if they can, whether that's by using their master's degree or the bachelor's and 5 years of experience. That's historically been the case, but it can change. There was kind of like this freak moment in 2020 where things flipped and there's a big rush to file. So we rely on the visa bulletin every single month to show us, to kind of guide us in whose turn it is next. Um, I just want to make a quick note about some of the last two visa categories that we don't typically see at our firm, but are also noted here. So there's EB4, which is a mixed bag of visa categories. This would include religious workers, special immigrant juveniles, certain broadcasters, certain retired officers of G4 international organizations, NATO, um, members of the armed forces, certain physicians that were licensed as of 1978. So it's just it's a really mixed
Yeah.
bag of classifications. And there's been a lot of attention, I think, on this visa category in the last year or so because it's retrogressed quite a bit, where it was historically current. It's backlogged. As you can see, they're working on um, petitions with priority dates from 2021. So that's significant, particularly for, like, I'm thinking of religious workers that only have a maximum of 5 years in their R1. And if they haven't gotten their green cards by then, they're out in a little bit of a limbo position if they haven't filed their green cards yet. And then there's the EB5 category, which is for investors, including their spouses and minor children, who make the necessary investment in a commercial enterprise in the US and plan to either create or preserve 10 permanent full-time jobs for qualified US workers. So that's EB4 and EB5. Again, we don't see this a ton at our firm, but there are certainly firms that do have a special focus on that.
I'm going to also jump in that there in EB1, there's also EB1B, and we can help with this too. It's just we don't see it as often, so we didn't focus on it for the purposes of this webinar. EB1B is for outstanding professors and researchers. So if you are someone working in those areas with an offer from a US employer and at least 3 years of experience in research or teaching, that could be an option for you too.
Okay. And Anna touched on this next process, but here it's to help you kind of visualize what we're talking about. The I-140 petition is the first application that's going to get filed with immigration. And where the Department of Labor has now agreed with us that there's no US workers that are available, the I-140 is now identifying you, the employee, you're the one. You fit the criteria. And this is where we present those experience letters that you got in the very beginning, your education credentials, um,
Trans-
and a letter of support from your employer, just confirming the job offer is still there. What happens next kind of depends on where you are in the world, what country you're from, and that's pretty, yeah. And what visas are available at in that moment in time. So if you are in the United States and your visa category is current, you can file an adjustment of status, a green card application. This could be filed along with your I-140 petition in one giant package, along with applications for a work permit, an advanced parole, or a travel card. You can include dependents at this stage, And this is the part of the process where employees can pitch in for the costs. Employers typically do, but not always. And so that'll be, again, up between you and employer. The timing this timing is based on what we're seeing right now in this moment in time. I-140 petitions, if you let them process normally, can take 6 to 9 months. But this is the one place where you can pay an extra fee to the government to get a decision within 2 weeks. So for folks who are from China and India that are on H-1B, this is critical because, as you might know, you can only be an H-1B for so long. It gets capped at 6 years. But if you have an approved I-140 petition, you can then extend your H-1B beyond the 6 years. You can get a work permit for your spouse. And so for some, this part is going to be like super important to get decided quickly. The adjustment of status or the green card application, that has to process naturally. There's no premium option for that. Typically, we see work permits being issued in like 3 to 4 months. Advanced parole is a little bit more unpredictable. Some clients get it at the same time as a work permit, some get it a little later, and then some don't get it at all. They just get the green card. Um, now,
That happened with a few cases recently where
yeah,
green card just comes in that much quicker.
right.
Um, Quickly going back, sorry, Catherine, about the I-140 and premium. I want to just touch on the non-perm categories that I spoke on earlier. So premium is available for all of those I-140s as well. Those are all I-140 petitions. So with those, you are not dealing with the Department of Labor at all because there's no perm associated with them. You are just going straight to the I-140, and you can expedite. For EB1A, it's the normal 15 business day turnaround. For EB1C, for multinational managers, and EB2 national interest waivers, it's a 45 business day turnaround. So it's a little bit longer, but still quicker than regular processing times.
Okay. And then if you are, if your visa category is not current, but you are in the US, you're in status, you might just stop at the I-140 for now. Be able to renew your H-1B and then wait until your number is called to complete this last part, the green card application. And I don't know if you want to go through the consular side of things.
Yeah, so if you're filing from abroad or if you're not in the United States, or if you're somebody that really needs flexibility to travel, because for a chunk of the time on while the AOS adjustment of status is pending, while we wait for that EAD or advanced parole, you're kind of stuck in the United States. And we have some folks that are CEOs of big companies and cannot sit still for 3 to 5 months. Their presence is needed overseas. So in those cases, you may consider just opting for consular processing. And with that, you're not dealing with USCIS for the final stage. You're actually working with the National Visa Center. So the approved I-140 will go to the National Visa Center and you'll pay the fees online. You'll upload the documents that they or provide the documents that they request from you, birth certificate, marriage certificate, anything else that they list there. And then they'll let you know, okay, you've met the document requirement. Now sit tight while we communicate directly with the embassy or the consulate in your home country. So, we're going to talk to the London embassy and we'll let you know when an appointment is available. They will reach out when a visa interview is available for you. That timeline's just going to depend on the local embassy's appointment availability and how busy their schedule is. So there's no real way to predict that. But once you go in for the interview, you'll go in with medicals. You will attend an in-person interview. And then, if approved, your passport will be stamped with something indicating that you'll be entering as a lawful permanent resident. After you enter the US, as a permanent resident, within a few weeks, the actual physical green card will be mailed to your US address.
I just want to call out maybe the elephant in the room that we haven't talked about. How will all of this sort of change in the next administration? Well, we've been through that administration once before, so we have a bit of like reference that we can go to for how things differed. In the adjustment of status route, right now we're not seeing interviews for employment-based green card applicants for the most part. We could see that again. That was something that we did see last time. These processing times could change. Um, we don't know if, just adjudication standards could become more stringent. RFEs could become, more frequent. So it's a big TBD here, but when the last time around, um, immigration attorneys across the country, I think all kind of like stepped up their game, made their applications more robust, and we never scaled back from that. So in some sense, I think we're ready to approach this new season, but I just want to flag here that these times could look a little bit different next year.
It's an important flag, Catherine. I would say expect and prepare for, like she said, more requests for evidence, maybe longer processing times because those additional requests and maybe added interviews will take more time, but it's nothing we haven't dealt with before. We are ready. We are ready to build strong cases just as we did 4 years ago. And as she said, most of us have never scaled back. So it's just continuing full force, and seeing and kind of monitoring trends. Immigration lawyers, we do keep in touch, nationally. And so we're always monitoring trends in RFEs and adjusting our strategies for our filings from there.
I don't think I have to say this in the employment-based context, but you shouldn't do any of this without an attorney. Even if it's not us, you'll want to use an attorney that is like regularly practicing this type of law because as Anna mentioned, our community of advocates is in touch with each other. We ask what's happening at this embassy, what kind of RFEs are you seeing? We share information generously, and so whatever firm that you choose to go with for your employment-based matters, make sure that they are licensed and practicing regularly. We are, of course, here to answer. You can schedule a consultation. You can DM us on all of our socials, and we're happy to provide some general info. And during a consultation, of course, we can get into the nitty-gritty of your situation. Here's one that's come through. What's your experience with TN visa status changes into a green card as a Canadian? Hmm.
That's an interesting question because the TN, for those who don't know, is a non-immigrant intent visa. So that means you are technically the intent is not to stay here permanently, or to have that intent, and to just temporarily come in, work on the TN, and then go back to Canada or Mexico as well. I've seen two approaches to this. So there's some attorneys that take a very strict, some attorneys and companies, I should also add, because it is an employment-based green card route, that would take a very strict stance and say, no, it's not worth the risk. You need to switch to an H-1B prior to starting a perm. Catherine, do you have any thoughts on that? Or have you seen any companies start a perm? I've also seen companies that are fine starting a perm and even doing the I-140, but then we just need to be very careful with your entry to the US once we reach the adjustment of status stage. So
Yeah. I was
it
going to say we do have clients that go the route of, they're fine with going from TN to green card, but we have to be really mindful about timing. For that first large chunk of the process, the perm, um, it's sort of, it doesn't matter so much like how often you're coming in and out, but once we get to stages 2 and 3, it will really matter. There's no and once we file the green card application or go for consular processing, there's no renewing that TN or coming back in. Um, Statuses like, or visas like H-1B and L are unique in that they are dual intent.
Mhm.
You can be on H or L, renew H or L, and then pursue the green card option just fine, no issue. But with TN, it's not like that. So that's one big consideration.
And so just making sure that you're having that open dialogue with your HR, with the company and with the attorneys, so that everybody's on the same page because, as Catherine said, there's going to be a lot of just careful watching of dates and the timeline. So great question. Thank you for sending that.
This is how you can get in touch with us. Um, and we're here. We're here for you, okay? So, and I don't know if there's anything else we need to cover.
Nothing else. I just want to say if you're feeling unsure, especially with some of the categories I spoke about, the extraordinary abilities, don't write yourself off yet. You may be more extraordinary than you think, so you may not need to go the perm route. And so just don't hesitate to reach out for a consult. Even if your profile isn't quite there yet, let an attorney, doesn't have to be us, but let an attorney look at it and let you know and maybe give you tips on areas that you might want to build to have a stronger EB1 so that, you can take advantage of those faster visa bulletin times. But thank you for joining us. We hope this has been helpful. And that's it.
All right. Thank you guys. Bye-bye.